Good afternoon, everyone, and thank you for joining us. Welcome to today's webinar titled The No-Fault Divorce and the Right to Family Life in Africa, which is a conversation about the High Court of the Kenyan judgment in Coppler Attorneys and another versus the Attorney General of the Republic of Kenya and another. Well, we're so pleased to have such a diverse group of participants with us. So before we begin, I would like to just handle a bit of the housekeeping. I'd ask that all the participants please introduce themselves in the chat and let us know from where they're coming from and where they're listening into this conversation from. We'd also like that please would you keep your microphones muted unless you are speaking. And we do invite that you share comments or any reflections in the chat during this discussion. We will have a Q&A session at the end, so please hold your questions until then or post them in the chat as they come up. So I'd first like to introduce our incredible panelists and then give you a context and framing of what this conversation is about and basically the roadmap of what we're hoping to accomplish and achieve in today's conversation. So our first panelist is COD White, who is an international development lawyer and gender expert with 30 years of experience in strategic gender lawyering, law reforms, and gender policy. She has consulted for numerous international organizations and holds a law degree and a master's, a law degree from the University of Botswana and a master's in gender and development from the University of Sussex. COD has founded WLSA Malawi and has led major law reform initiatives. She's also a published author. We then have Advocate Christine Mutoni, who is an advocate of the High Court in Kenya with over a decade of experience in family law, women's rights, and socioeconomic justice. She is also a certified divorce coach and author of 2 books. She has founded various concepts that basically underline the program to help people navigate divorce with dignity, emotional intelligence, and self-awareness. Her work combines law, healing, and empowerment to support women through life transitions and challenge patriarchal norms. We then have our very own Caroline Kituku, who is also an advocate of the High Court in Kenya, who possesses both an LLB and an LLM and a postgraduate diploma from the Kenya School of Law. She is the lead lawyer of the Women's Socioeconomic Rights thematic area at ISLA, and her work focuses on strategic litigation, advancing women's property rights, especially in family law, inheritance, and cohabitation contexts. She uses a feminist and substantive equality lens to litigate these matters, and she has successfully litigated constitutional and human rights cases in Kenya and before the African human rights system. We then have Aria Carijo, who is a narrative weaver, a researcher, and a former feminist investigative journalist. She is also a community organizer and activist. She grounds her work and describes it as being grounded in a trans feminist and African feminist lens, embodying a captive maternal role in liberatory struggles and social transformation. We lastly have the Honorable Justice Mwamba Chanda, who is a judge of the High Court of Zambia, who was appointed in 2014. She holds an LLB from the University of Zambia and was admitted to the bar in 2000. She has held various judicial roles, including Magistrate Registrar of the High Court, the Director of Court Operations, and she also currently serves as the Secretary of the Judicial Services Commission. She's also served as the Secretary of the Judicial Service Commission and Council of Law Reporting. So that is our panelist, and they will be basically handling the conversation that we will be having today. And just to sort of paint the picture, why we're trying to have this conversation is that in most African countries, wherever a party to a marriage has petitioned for divorce, the divorce requires the party to establish sufficiently any of the contemplated grounds on whose fault it was, causing the marriage to fail before the court can grant the order for the dissolution of the marriage. And some of these contemplated grounds include things like adultery, cruelty, desertion, exceptional depravity, and irretrievable breakdown of marriage. And so over the past few decades, there have been efforts across the continent to change this law, to ease the process of bringing an end to an already ended marriage, and to do so legally through a divorce without resorting to blaming either party. So this removes the need to antagonize parties to the marriages, and we're trying to do this thing where the shift is founded on the commitment to human rights, gender equality, and autonomy. And by embracing this no-fault divorce law, it makes the separation through divorce less complicated, inexpensive, and non-conflictual. I believe that our panelists can tell you a bit better than I can. So what I will then go on to state is that this webinar will address and basically unpack the inherent problem with the fault-based divorce system, explore the possibility of a no-fault divorce law in Africa, consider the role of family values, if any, on a no-fault divorce law, provide a comparative perspective from the African region, and reimagine an ideal divorce law within the African continent. So I now move to our incredible panelists, and I'd like to pose my first question to COD White, which is, how has the fault-based system of divorce historically undermined the principle of substantive equality?
Thank you very much. First of all, before I respond substantively to that question, let me also take this opportunity, first of all, to thank Isla for inviting us to this seminar, and to all those who are attending the seminar. And also, I want to delve into quickly into the issue of substantive equality, because we might assume everybody understands what we're talking about. So for the purposes of making a clear understanding why substantive equality is important, as you know, the CEDAW Convention and the interpretation that has been given to the letters of the CEDAW by the committee over and over, the committee has actually indicated that the CEDAW should be read from a substantive equality perspective and formal equality perspective. And formal equality means the obligations of member states, countries, to come up with laws aimed at achieving gender equality. And substantive equality means the experience of such laws should actually promote gender equality. They should not have a neutral effect or even a retro effect. They should, in themselves, by existing, they should come alive and support women's equality. So now let's come back to your question. Why is this important from a substantive equality perspective? Now, divorce in itself is not a gender neutral subject. It's not that the effect, the process, as well as the effect of it, that affects men and women equally. It doesn't. So some of African countries, I would say even the majority of African countries, obtained their law, their formal law. You find out that in the English system then, men could divorce women based on adultery, and women could only divorce men based on grievous adultery. And what was grievous adultery? It was things like incest and rape, things like that. That is the only time that women could go to court for divorce. So you can see that the origins of divorce in themselves already from the time it started in England, that there was a difference in terms of who could divorce and why. Over the years, in different African countries, the reasons, the grounds, if we can use that, for divorce have changed. But however, if you look at now the effect of the same, it's not the same, because the need to prove itself it's very contentious. And as you know, in matters of divorce, matters of contention and strife affect women negatively, because that means they'll have to have the right expertise to prove that the other party has engaged in in an offensive act, as based on the law. Women normally do not have enough funds. They're usually, up to this day, unfortunately, in 2025, most women are still being supported by their spouses, or where they're not 100% supported, they are the ones who earn lesser. So when matters of divorce come through, you find out that they have to get the right expertise, which they usually fail, and they would either stay in a very difficult situation, like where there's domestic violence, because they simply cannot prove how bad things are. And generally, I think going forward, when you think of, it looks like a finger pointing thing of who was wrong and who was right. And yet we know very well that generally it's not that simple. Matters of divorce are not that simple. They're not about who did the wrong thing and who did the right thing. So the main thing that I'm driving here is to say divorce as a construct is not neutral. Divorce as a construct is gendered. And at the end of the day, if you put fault to the divorce, women most likely are there to lose, because the competition to show who was wrong would most likely, it's mainly men who would win it, because women have zero economic, not zero, of course, that's not true, but the economic power is limited. That's one of the reasons I can raise. I mean, there are many, but it's the fact that divorce in itself is a gendered construct, and it affects women most likely negatively, and putting an offense to it pushes women to prove what went wrong, and most of the time they'll not prove, and they'll end up staying in very difficult marriages.
Thank you, sir. That's a very interesting concept in terms of how gender is actually, divorce in and of itself is not gender neutral. So then I would pose the question to you, that is fault-based divorce law therefore a women's rights issue? And before you answer that, anyone who needs a French interpretation, please find it. It's available on one of the icons titled interpretation. But yes, Yodi, do you think is fault-based divorce law therefore a women's rights issue? And what's your opinion on that?
Yes, it is a women's rights issue. Let's start with the CEDAW convention in itself. If you allow me, let me just read what the committee has said about this, so that I bring to the understanding how this has played out at that global level with regards to women's rights. Just 1 second. So basically, if you look at what the CEDAW committee has said, it has said that the committee has consistently concluded that the elimination of discrimination against women requires states parties to provide for substantive as well as formal equality. Formal equality may be achieved by adopting gender neutral laws and policies which on their face treat women and men equally. Substantive equality can be achieved only when states parties examine the application and effects of laws and policies and ensure that they provide for equality, in fact, accounting for women's disadvantage or exclusion. So when you look at what the committee has said, is that, for example, a divorce law, on the face of it, if it looks neutral, but then when you apply it, it affects women differently. Member states have an obligation to review those laws, because that law obviously does not promote women's rights. And if you look at Article 2 of the African Charter on Human and People's Rights, it states that every individual shall be entitled to the enjoyment of the rights and freedoms recognized and guaranteed in the Charter without distinction of any kind, such as race, ethnic group, color, sex, language, religion, political, or any other opinion, national or social origin, fortune, birth, or other. So, and further on, the African Charter, under Article 18, further stipulates that the state shall ensure that the elimination of every discrimination against women and also ensure the protection of the rights of the women. Now, let's tie in these two factors, the obligations, the international as well as the domestic obligations of member states. Most member states have constitutions which promote and women's rights and actually prohibit discrimination. And then we have, and the member states are also obliged under international law, such as the ones I've read under the CEDAW and the African Charter, to eliminate laws that discriminate against women. Now, when you take the point of the letter of the law, form equality, and the effect of the law, substantive equality, and marry those, and you look at the nature and framework of laws that are on paper that are looking at divorce, and they have clauses that put fault, you find out that the effect of those laws does not promote women's rights. It actually, discriminates against women. So, it's not a rocket science. And I think at this point, in the whole conversation around women's rights, yes, we still have a lot of states that are member states that do have discriminatory laws very clearly, but most member states, particularly in their constitutions, protect gender equality. It's now we are at that stage whereby we have to look at the effect of those laws, because member states have become experts at enacting very beautiful laws promoting gender equality. But we know very well that the effect of the same is a problem. And I think now we're at that stage where when you look at the divorce laws, we should know that the contention which arises in matters of divorce can really, to be honest, never be an equal playing field for men and women. It's very difficult, as you know. So this is where member states need to change these laws from fault-based divorce laws to non-fault, so that the substantive equality, the experience of the law, should actually feel real in real life. Thank you.
Thank you so much, COD. Now turning to Christine. If we are rethinking divorce without adversarial blame, in your experience, what has been the most harmful consequences of fault-based divorce system?
Thank you, Sena, for that question. And I would say that the consequences are numerous. They are so many, but I'm just going to limit them to three. First of all, let's say that out of all the divorces that are filed, it is said statistically that 70% are initiated by women. And so if you're the one who is initiating, it means that you're the one who is finding fault in your spouse, and the task is upon you to provide evidence of your allegations. And so as the woman, you have such a heavy burden. Already the marriage was bad, and that is why now you're filing for divorce. And so the process also makes an already bad situation worse. So the consequences, I have divided them into legal consequences, emotional consequences, and strategic consequences. So let me start with the legal consequences. When you go to court and you have these allegations, you're opening yourself to scrutiny. And this scrutiny is not just scrutiny by the court. It is public scrutiny, because in most instances, we find that court is open. Everybody is there, unless you ask to be heard in camera. And so you will be asked some questions that really put you bare, you're exposed. And even these records are they're public. Anyone who wants to see them can see them at any one point. And so what I have observed with the cases that I have dealt with is that the court is a human being, just like you and I, and they have their own biases as well. So they will ask questions that are going to help them to reach a determination. And some of these questions are very sensitive, and that scrutiny leaves you so traumatized, it leaves you so hurt and so damaged that if you are going to court for a remedy, you find that it's more punitive than remedial. And so it leaves this woman in such a vulnerable position, By the way, when you're going through divorce, the divorce is just a bump, because I believe divorce is just one small aspect of uncoupling, because uncoupling involves so much more. By the time you're contemplating leaving that marriage, by the time you're explaining to your family, to your friends, to your children, by the time you're facing stigma from your circles, your church, your everything, all that is already so traumatic. You're so vulnerable. You're so fragile. You need to be handled with care. But then there's this legal bit that you have to go through, the divorce process, and then you go to court and you're going through scrutiny. Sometimes you're even a public figure, yeah, and so you're exposed. You have to go there and talk about all the issues that you're going through or you have gone through in your marriage, which most of the time are embarrassing, because people don't get divorced because they're really happy. People get divorced because they've had so many problems and challenges and they just want to get it over and done with. Which leads me to the second consequence, which is emotional. I know of people who have been divorced 10 years plus who have never healed, because the process itself was so adversarial, it was so litigious, it was so acrimonious that it leaves permanent scars. So anytime you remember what happened and you remember the stigma of being a divorcee, it puts you back in that state, like it's happening right now. People are depressed, they never get over it. They say that women are emotional beings. I believe all human beings are emotional beings, but it affects women more than it does men. That's why you find that most divorcee men remarry quite quickly. But for women, they stay there, unable to find themselves again, unable to recover, mostly because of what they went through, the traumatic experience in court, where they had to rehash everything that happened to them and try to prove it enough for the court to be convinced and grant them their prayers in the petition. And then lastly, it affects your strategy, because most of the time after the divorce, women are the ones who have physical and actual custody of the children, meaning that whenever you're leaving that marriage, you're taking your children with you. But if you had been put through this process of proving fault and placing blame on the father of your children, remember that even when he's no longer your husband, he's still going to be the father of your children. But now when you were put in this position where you had to find fault and place blame, and sometimes it was terrible, now you don't have a negotiating ground, because how do you come and say, I need child support, I still want you to be present for the children, I still want us to co-parent in a cordial manner, when the divorce process was so acrimonious? You see, it's really tricky, it's difficult. And so the strategic bit of it is already compromised. And then you're left with no foundation to start your life afresh. It also exposes you to retaliation, because the moment you're served with divorce papers, the first thing you feel is defensive as a man, even as a woman. But now we're looking at it when the women are the majority who are filing, they're initiating. So you're finding fault in the father of your children. And so he's, of course, going to get defensive, and he will want to retaliate. And the retaliation sometimes can be very negative. And it doesn't just affect you as the ex-wife, but your children. And now you can't co-parent. When it comes to property, you can't even divide property, because now it's about you're trying to disenfranchise me. It's no longer about we're just dissolving the marital status. It's a war. It's about ego. It's about, I'm going to show you, I'm going to put you in your place. And so, in my opinion, the fault-based divorce system really has negative consequences and effects on women, their rights, and their life thereafter.
Thank you, Christine. That's very interesting. Just to follow up on that, I would ask you, how would a no-fault divorce law system assist in the development of the family law?
All right, so family law is broad. We have the divorce bit of it, we have the children matters, and we have the division of matrimonial property. Now, what I would say is that the children bit of it and the matrimonial property bit of it all depends on how the divorce went. So if we had a no-fault system, it would mean that we are not being pitted against each other. And so the system would just allow us to read the writing on the wall that it's not working anymore, so let's call it quits, without all this acrimony and all this fighting and the court and the scrutiny and the embarrassment and everything. So if we have separated consciously, knowing that it's not working, then the children part of it, the law in the Children's Act and the law in the Matrimonial Properties Act, can be able to be applied without the bitter taste in our mouths that was left in the divorce. Because I think all this, we'll always think about what happened in the divorce as we are looking at how do we handle the children, and as we are looking at how do we handle the division of matrimonial property. And I think that implementing these laws, these other laws, would be so much easier, because already we are coming with clean hands and clean hearts, and we are ready to look at the future of what we've built together. We have a family, and we have businesses, and we have property. Now we're not looking at you're my enemy and I'm your enemy. We are looking at how can we look at the best interest of the children, and how can we share this property in a manner that is fair, and also considering who has bigger responsibilities with the children. So yeah, no-fault divorce would really help the other laws in family.
Thank you so much, Christine. Over to Carol, as someone who can provide us a comparative perspective of the law in Africa and legal reforms through the courts, in your view, how are the divorce law frameworks in African countries structured?
Thank you so much, Senna, for that question. So I will start by perhaps saying that in Africa, we have two systems of the fault-based divorce, two systems of the divorce law. And there is a reason that this is so, because obviously there is the impact of colonialism, where we see that the law did not originate from Africa, but it came in through the English people, through the colonialism effect, and they became law by what in most of the African states is called the deception clause, that the laws that were in England at a certain time when the colonialists came were imported into our African countries. So the way the law has been evolved and the way it has been structured is that in most of those countries, the law has remained as it was in England the day it was brought into the African continent. So then I will discuss about the two systems. So we have obviously the fault-based entire system, whereby for one to get a divorce, you must go to court and you must try to establish why you want a divorce and provide the reasons for divorce and actually demonstrate that there is fault in your spouse for the court to be convinced that actually you should dissolve the marriage. So when that applies in countries like Uganda, it applies in countries like Nigeria, whereby the divorce law in those respective countries speaks about the various grounds that one must establish for them to be enabled to get a divorce by the court. We have another system that, in my view, I call it hybrid system, in the sense that it has both the fault-based system and it has a semblance of a no-fault divorce system, but in the end, it ends up being a fault-based divorce system. So what am I saying? A good example would be Kenya, or a good example would be Tanzania, Ghana, where in these countries, we have the law that provides for the grounds for divorce, And you find that among those grounds for divorce, we have one particular ground for divorce that is very peculiar, that is called the irretrievable or the irreparable breakdown of marriage, to say that the marriage has broken down irreparably, that there is no hope that this marriage can be saved by any of the parties involved. So what does that mean? That in these countries, particularly the case in Kenya, the case in Tanzania, the case in Ghana, Zimbabwe, and Malawi, you will find that the law has established the grounds for divorce, that for you to go to get a divorce, you must establish either adultery, you must establish cruelty, desertion. Nigeria has a very interesting one that is called, Nigeria has an interesting example that is called unreasonable behavior and separation or absence. So when you go to court, you must establish any of this. When you claim that there was adultery, when you claim that there was unreasonable behavior, there was cruelty, you must provide evidence, you must provide facts that lead to that conclusion, and that will enable the judge that is handling the divorce case to reach that conclusion that indeed that this offense was committed in the marriage, and therefore you should be granted a divorce. That's what we call the fault-based divorce system. Then you will find that in these same countries like Kenya, Tanzania, Ghana, Zimbabwe, you have another separate ground that is called the irretrievable breakdown of marriages. Why am I emphasizing on this? It is because in those countries that do not have a fault-based divorce system, you find that in their laws, they only have one ground of divorce, which is the irretrievable breakdown of marriage. So in the countries that have taken this as part of the fault, then they have to go a second step. Then you have to establish the irretrievable breakdown of marriage by demonstrating the grounds of divorce. So basically, it is not enough for you to go to court and say that the marriage has broken down irretrievably. You must now provide evidence. You must provide why that you are saying that the marriage has broken down irretrievably by attaching the earlier grounds of divorce, by establishing, for example, cruelty, by establishing adultery. And that's why the system is hybrid, but not really, like, in the sense that it is not clear, so that there's confusion. It's both fault-based and it is also both not fault-based. But in practice, and what happens in court is that the system is fault-based, because if you have to establish the irretrievable breakdown of marriage, then it ends up being a fault-based divorce system. So that is in certain countries. Then you will now find this category of countries that's purely fault-based divorce system. This will be applicable in South Africa. It will be applicable in South Africa, where you find that there is only one single grounds for divorce, which is irretrievable breakdown of marriage. So in these countries that do not have the fault, the need to establish fault, a party to the marriage just approaches the court, and you make a statement that the marriage has broken down irretrievably, and the statute and the law that governs that has given certain indicators on what irretrievable breakdown means. For example, you've been separated for a very long period of time. In Namibia, it's 2 years. In South Africa, same. So if you have been separated for a certain duration of time, you're living your life separately, and there's no marital community, then it means that the marriage is broken down irretrievably. You need not go further and establish any other grounds that speak to the irretrievable breakdown of marriage. It is just enough to go to court on that account. Thank you, Sam.
Thank you, Carol. And you have been involved in a litigation of 2 cases that sort of sought to challenge the constitutional validity of a fault-based divorce system in Kenya. That is the Coppler Attorneys case, as well as in Uganda, the Innocent Ngobi and others case. So with your experience, how did the courts approach the legal issues before it?
Right. Thank you, Sana, for the question. So in Kenya, the Coppler Attorneys case, in that case, the petitioners had challenged and argued that the law that establishes the grounds for divorce violated Article 45 of the Kenyan Constitution. Article 45 speaks about the right of every adult person to marry a person of the opposite sex, based on the consent of that party. So the petitioners in the case argued that to the extent that the law that establishes the grounds of divorce required you to establish the grounds of divorce before you can get a divorce, meant that the divorce proceedings were convoluted even when parties were willing to separate and end the marriage, and therefore it was a violation of their rights as individuals in that marriage. So in this particular case, Easter and FIDA Kenya were amicus in the matter, and we sought to establish to the court why the law, even if it was gender neutral, in the sense that it required the spouses to establish the grounds of divorce, it had a disproportionate impact on women and to service the gender inequalities that are there in the matrimonial laws due to stereotypes and the gender inequalities and power relations that have subjugated women over the years to unequal power and lack of equality in matrimonial laws and in marriages. So, and basically to establish to the court the effect of the law that most couples actually get stuck in marriages that they would not want to be in, and because they're reluctant to expose their very intimate details, and therefore basically it's a rights issue, because to that extent it violates certain rights in the Bill of Rights. So the court did not find any merits in any of these arguments, and basically it found that the law that seeks to establish the grounds for divorce and the fault in a party before a divorce can be granted is a societal need. There's a societal need to preserve the law, because in the court's view, marriage is a societal institution in the sense that it goes beyond the two parties that are involved. It involves the families, it involves the friends, it involves the religious perspectives, it involves the government, it involves the community. So to that extent, therefore, there was need to preserve the marriage. And in the court's view, by letting this law go, then we are just basically opening up marriages to casual dissolution. And basically, violating Article 45 that requires the government to protect and preserve the institution of the marriage. So that was how the court in the Coppler Attorneys case in Kenya approached the issues. Now, in Uganda, there was a similar contest, or rather, there was a similar issue that arose, and the petitioners in that case had gone to court in the Constitutional Court of Uganda to challenge the fault-based divorce law and the law that basically requires parties to establish the grounds for divorce as is put in the Divorce Act in Uganda. Similarly, the court failed to recognize what are the inherent problems that exist in the gender-neutral law and the effect that it had on parties. The court actually relied very heavily on the Kenyan jurisprudence and the Kenyan case that I've just spoken about to find that family and marriage are societal interests. They are protected in the Ugandan constitution, and therefore there is a need to preserve marriages, because families are important, and therefore the court must get involved in dissolution and regulating how marriages should be dissolved. Interesting, in this case, the petitioners actually argued that the requirement that parties need to establish any of the grounds for divorce amounted to violation of what the institution of marriage is all about, that it is based on consent. So that by the time a party has approached court to ask for an order of divorce, according to the petitioners, they were telling the court, by that time they've withdrawn their consent. And therefore, it should be deemed that the marriage has come to an end because there's no consent from any of the parties in the marriage. And therefore, the only thing that should happen is to dissolve that marriage. And refusal to do so amounts to coercion, in the sense that it is coercing the parties to continue living together, even when parties do not want to continue being married and to continue being in that family relationship. Another interesting aspect that came out of the Ugandan court was the petitioner's argument that said that, to the extent that parties are being forced to return to rehearse and establish to the court through facts and evidence the reasons why the marriage should broke down is actually very torturous. It is inhumane, and basically it is in the perspective of private life into the open public domain, where a third party gets involved to determine what should happen. So that is what happened in Uganda, and that's what has happened in Kenya. Thank you, Sena.
Thank you, Carol. And you mentioned something that is very significant to our next speaker, Arya. Arya, I would love for you to basically, following up from the reasoning of the court in these two cases, I would love for you to sort of expand on why is the use of family values, societal interests, and religious perspectives by the court problematic in the context of the application of the right to equality in marriage, autonomy, and the right to find a family.
Thank you, Sena. Yeah, and like you rightly said, Caroline, COD, and everyone else has really like covered the aspects of this case. And I think before I get into particular examples with the ruling that came from this particular case, I'd like maybe to define narratives, because I feel I'll keep repeating the word and it's important to my explanation. Narratives, I'm reading. So narratives are structured accounts, representations, and frameworks that human beings use to make sense of the world. So to understand issues, to understand communities, to understand social norms, we use narratives. And they're so subconscious that we regard them as common sense. And these stories, these structured accounts can be personal, they can be cultural, they can be historical, and they can also be political. So when my fellow panelists stated about the colonial history of divorce and all of this is cultural. This is something that we've been, it's cultural, it's historical, and there's like political aspects. Second thing is narratives serve to inform, persuade, educate, and influence audiences. Some narratives generate otherness, so they create a social enemy. So a narrative which talks about, this and this group of people are terrorists. So it creates a social enemy. So even if someone does not fit the bill of being a terrorist, a narrative has been formed. If someone looks in some way, they're a terrorist. And again, this is important because we have to look at the narratives around marriage and family. Some narratives reinforce a way of being and seeing life. So especially in this case, all of us who are arguing within a particular framework, when we are going for divorce or not to divorce, we have a narrative of what we see marriage as. And then we also have a narrative of what we see marriage and family to be, because they're not the same things. But if you look at the judgment of the judge, in his mind, he has a fallacious argument that marriage, so he starts with, like marriage. Okay, I'll get into the example. Let me not get ahead of myself. And then really the final thing, which is really important to when I start looking at the case, is that family is also a narratives container. So we have narratives, which are ways of seeing, structured frameworks, ways of seeing and understanding the way we are in the world. But then sometimes we have containers for narratives, and containers can be real or fictional vehicles that carry multiple themes, multiple perspectives. And so family is not just a relational unit of people. Yes, it's me marrying someone else, having children, a grandmother, a grandfather, that's family, yes. But also in the way we speak about family, even the way we've spoken about it here, we see it as a vehicle for some ideas of belonging, good citizenship, who is morally okay, who's seen as good or not good, which is why in divorce, then you find people arguing that, oh, he did this, she did that, because in this framework of the family, there's an idea of morality. This family as a narratives container, we've built some narratives that if you're not good enough, then you can't fit in this. So you have to prove your partner is bad in some way in order to end this arrangement. So So family as a narratives container. Why is this important? As lawyers, as judges, as people in the legal profession, I am not, but it is important because one, when you go to court, you have to think through narratives to give your intervention efficacy. Efficacy in terms of what you're asking the court for, and in terms of what you state is the violation. Because if we don't look at it through a narratives lens, we'll take a very narrow thing while it could be like a big issue. Then finally, often containers of narratives, so containers like the family, carry fallacious arguments. And I've mentioned the judge, which I will explain when I start giving examples directly from the case. Secondly, sometimes they can carry misrepresentations. And finally, they prevent us from seeing facts. And facts are very important to like making judgments. Why narratives prevent us from seeing facts? Because they elicit an emotive response. I think one of my fellow panelists said, you're accusing someone of being bad, so they fight back. But also, even aside from the parties in the divorce, everyone else is also a participant in the family narrative. So it's like, or if I rule in this way, what am I saying about my family, or what am I saying about? So there's that kind of emotive response where we all get defensive. Aside from the parties, everyone who's participating in that, whether it's the public who are listening to the proceedings, the judge, the lawyers, everyone has an aspect of defending their own perspectives. Remember, we said narratives is a perspective on the way we see, make sense of the world. So, okay, getting into the case, if you want, should I get into that, or do you have like the follow-up?
I do have another question, so you can
Yes.
just think about it as you get into the case. So how do you see the court's use of family values and societal interests to protect marriages as generally intersecting with the broader anti-rights narratives on human rights work in Africa within the context of family law?
All right, so there we have anti-rights. We also have, and I'll also mention what's the idea of anti-rights. So in the judgment, so I was reading this particular judgment from I don't know if you call it a clause, from number 17, the judge is ruling, all the way to 78. And those are like the last pieces. And so in 71, the judge talks about, prior to 71, there's the bits where they talk about, the objects and purposes of the statutes, and then the unconstitutional effect. And those, I think, COD has covered. There's an effect, of course, which is negative on women. But in the judgment, they're not used in the way COD says. In the judgment, they're used in the opposite to say that there's no unconstitutional effect, and basically, yes, yeah. So, and then the 70 and 71 talks about the Constitution of Kenya. So chapter 45, and it's talking about the family. And so if you just read that bit of the Constitution, the parties in Article 45 of the Constitution of Kenya, the parties in that particular part of the Constitution is the family, which is said to be a unit and a foundation of society. That's what the Constitution talks about, and it says the state should recognize and the family should enjoy the protection. The other character, so in narratives we think of characters, plots, and the story. The other character in this part of the Constitution, so I'm reading it from a storyteller's perspective, is an adult party. And so the Constitution is talking about an adult party who has consent, who can get married. And then that's section 2. Then section 3, it says that these adult parties are equal at the beginning, during, and after the marriage, after the dissolution, yeah. And then finally, it does not only talk about like recognition and protection of the family, it also talks about recognition of culture, like enabling marriages that are based on culture. And so for me, if I was to take on part X, the Marriage Act in court, I think part Part X violates all of this because one, if you look at Part X, culturally, it only uses, again, we have the colonial perspective. That's the only thing that's used in Part X. If you look at Part X, the part that covers Christian, how to end a Christian marriage, how to end a Muslim marriage, how to end a cultural marriage, it's copy-paste. There is no variation. They don't look at culture in any way. So, and this is a red flag already. It shows we have understood families and marriage through a particular lens, and we've applied the lens to everyone. So again, the family in this particular part of the Constitution talks about recognition and protection, free consent. Those are the things being protected, and then equal rights. But then when you come to the judges, when you come to 72, 73, 74, 75, then it changes. The participant is no longer the family and the adult. There's a new participant called the society. And the society in this part has an interest in marriage. Up to this point, constitutionally, we don't have a definition of whose society, why are they there? But in the ruling, it comes up, and the judge says societies have an interest in marriage, and society is interested in ensuring success and not failure and reuniting couples. These are all things that were not conceived of in the Constitution. And so, and marriage, and then here's the fallacy. So marriages are the basis of stability in the family. That's a fallacy because we know there's families that do not necessarily have a married participants in them. They're still families. And then if marriages, this I'm reading from the judges, so marriages are the basis of stability of the family unit. And the family unit is the foundation of social order. And therefore, so this is the logical flow, which is already broken from the word go. And therefore, marriage is then at the foundation of social order. So we're taking out the family and inserting marriages as the replacement. And you'll only see this if you look at this through a narratives lens. So the judge, in other words, was concluding, if families should enjoy the protection of the state, so must marriages. And this, again, I could argue is a fallacy. You mentioned anti-rights, and a lot of anti-rights groups are introducing a new thing, so family values. But what really are family values? These are things, again, based on colonization, based on dominant narratives, and so they use these arguments to continue. And the thing with narratives is that once we consent to one thing, then we are forced to consent to another. So when we consent about all of these things about the families, when someone says family values, then because we agree to this other thing, then we cannot refuse on this. And yeah, so to conclude, I will say, yeah, with what the judge says, this solemn matter cannot be left to the casual wish of individuals. Literally just goes against the Constitution, but because the judge was also using a narratives lens and led us to this point of the judgment, then this conclusion of this makes sense. And our obligation of lawyers is also not just to argue the case, but also to make the judge see this other, what will be a blind side for the lawyers, for the participants, and for everyone. I think I will stop there, and I will answer anything else during the questions.
Thank you, Arya. To move this discussion towards almost to contribute a judicial point of view, Justice Mwamba Chanda, from your experience as the head of the family division of the High Court of Zambia, how have the courts in Zambia applied the fault-based law, and what patterns have you observed in how parties approach these cases?
Thank you very much, Sena. I'm honored and delighted to be part of this conversation. So to answer your question, in Zambia, the dissolution of marriage is governed by the Matrimonial Causes Act, which is Act number 20 of 2007. And this statute recognizes one ground for divorce, namely that the marriage has broken down irretrievably. And to establish this ground, the petitioner must satisfy the court of one or more of the statutory facts prescribed under Section 9 of the Act. And these facts include adultery, conduct amounting to unreasonable behavior, and unreasonable behavior, of course, is not defined. Conduct amounting to desertion for a continuous period of at least 2 years. And then there's also separation for 2 years with consent from the respondent. And the last fact is that the parties should have been on separation for a period of 5 years. This framework is in substance fault-based and closely mirrors the position that obtained in England and was prior to the reforms of April 2022, which introduced a no-fault divorce legislation. So in Zambia, the courts have consistently underscored that the burden of proof rests squarely on the petitioner. Where the alleged fact is not established, the court cannot find that the marriage has broken down irretrievably. Importantly, though, where a respondent pros petitions, the law imposes an equal obligation upon the respondent to prove the fact upon which the cross petition is founded. Thus, both parties stand or fall by the sufficiency of their respective evidence. So you find that in Zambia, we have like two systems. So, of course, when the petitioner is required to prove unreasonable behavior, adultery, in a way that is purely fault-based. So on the other hand, if they are bringing in the grounds of separation, they need not, of course, find fault. With 2 years separation, the only requirement is that the respondent should consent to the divorce. The court will then not ask what is causing the divorce. Whereas when you look at the 5 years separation, there will be no consent required. So the court will only establish that the parties have lived separately for a period of 5 years and the divorce will be granted. So I think essentially that is how we are dealing with the divorce cases in Zambia. And of course, it will be interesting for me to mention here that though we have these complications when it comes to fault-based divorces, with regard to statutory marriages, we also are faced with a dilemma as a country because our marriage system is dual. So you find that most of the parties that marry under statutory law, where the jurisdiction for divorce is the High Court, also fulfill some customary aspects. In other words, they also marry under customary law before they even go to convert their marriages to statutory ones. So you find that as we contend with the no-fault, the fault-based marriages, we are also contending to try and resolve disputes with parties having different customs. So you find that parties are always in a dilemma, especially women, in that before they come to court, they will have sat with their families, exhausted all these reasons, have their so-called kangaroo courts, and when the families fail to deal with the matter, then they are coming to court. And when they come to court, there's another hurdle. They need to now establish, satisfy the court that this is the person that is causing this marriage to end. So I think as a way of responding to your first question, that is what I can say for now.
Thank you, Justice. And from what you have observed, do you think the current fault-based framework adequately protects the interests of women in divorce proceedings?
In my considered view, the current fault-based legal framework does not protect the interest of women in divorce proceedings. in that there is always a potential for defamation and retribution. You find that allegations of fault can lead to accusation of misconduct, which might damage reputations or lead to retaliatory claims. I think I would want to put this into context by sharing with you a matter that I handled, which I'll call the Palmer case. This case, of course, was filed in 2020, the year 2020, and it was finally resolved in 2023. So briefly, the case was a petition by the woman using the 5 years separation. The husband, of course, was not contesting or was not refusing that the marriage should be dissolved. But of course, he wanted to bring to the attention of the court that it was actually the misbehavior of the wife that was causing this marriage to end. So what did he do? He then cross-petitioned. He cross-petitioned using the fact of adultery and unreasonable behavior. And in the process, he called to prove his claims. He called about 10 witnesses and also cited this alleged boyfriend of the wife, who he alleged committed adultery with the wife. And, you know, the case was so bad on the part of the woman in that the husband went to lengths to bring photographs, to bring maids to come and testify to her infidelity, to bring guards who he believed saw this woman bringing in the man. And of course, there was nothing that the court could do, because the nature of the law is that when a party alleges, they need to prove the matter beyond reasonable doubt. And how do they prove the matter? Of course, they need to bring in all this evidence. But you could see that the motive behind that was for the man to try and scandalize the woman. And along the way, as the proceedings were going on, the woman was so embarrassed that she abandoned coming to court. She would just let the lawyers come into court because it became a bad battleground. The court was now a forum where she was just basically undressed. So you can see that if we move to a no-fault based marriage, the husband was not in a way opposed to the marriage ending, but he just wanted to prove a point. And I could see that eventually he also did not want the wife to share into the matrimonial home that they had acquired jointly during the subsistence of the marriage, because of course he wanted to bring to the fore that there was this other man that the woman was seeing who should now be responsible for her. So that is one aspect where I feel this fault-based system does not protect the interests of the woman. Secondly, you find that there is psychological and emotional effects. The fault-based requirements has been well renowned for exacerbating emotional distress during proceedings, as parties, especially women, are compelled to confront and litigate personal and sensitive issues. So you find that most women would want these marriages to end amicably. But because there is this requirement that they should testify, they should prove beyond reasonable doubt, they are now just forced to go through everything that has been happening. And you know, when one goes into marriage, you do not envisage that the marriage would end. So you will not be taking stock of everything, keeping pictures, recording your friend. No, you will not do that. So at that stage, when the marriage is ending, I think that the system should be in such a way that it is user-friendly to the parties, especially to women. So you would find that in terms of even the legal strategy, this has been very difficult for women, because most women would be lost for words when it comes to them testifying, because they do believe that the system is made in such a way that it will re-traumatize them. Because if you do not put your documents together, if you do not call the witnesses to collaborate what you are saying before court, then the court would tell you that you have failed to prove your case and the case is thrown out. But in the meantime, you have reached your breaking point. So in a nutshell, the system is not helpful when it comes to the interests of women in divorce proceedings. Thank you very much.
Thank you, Justice, so much for that contribution. It is very, very, very imperative. So thank you to all our speakers for these insightful contributions. And before we move to our audience Q&A, I'd like to pose a few questions, a few reflective questions to our panel. But as I do that, I'd really like the participants and the viewers to also start posing their questions within the chat so that we can also get into the discussion as soon as possible. So, COD, what legal or procedural reforms would have to be prioritized to support a shift towards a no-fault divorce system?
Thank you very much. First of all, let me just give an entry point to say change is possible. I have a 30-year career in legal reform, and things that were normal 20 years ago, 15 years ago, over the years, changes have happened in so many countries. There is no reason why it can't happen in this particular legal framework, both substantively regards to the nature of the law, the framework of the law, as well as procedurally. So I'm so glad that Justice Chanda was able to, tell us what actually obtains in real life, and how parties inevitably abuse the system to embarrass, to prove themselves that they were right and this person is wrong. It's the nature of the separation. It's the nature of the activity, if I can say, the activity called divorce. Now, how do you change the law? The law is very simple. It's not a very difficult thing to change. There are two ways in which a legal reform happens in many countries. One, on its own motion. What I mean is that engagement with structures, with governance structures such as the central executive, the parliament. Those who talk about the executive, find many constitutions, laws originate from the executive, from cabinet, if I can use that. So we talk about the executive. Engagement with the executive also helps them to present laws to cabinet for effective law reform, which then go to parliament. After engagement, what I mean by engagement, I'm talking about meetings and stuff. So it's a very, very simple process where, a citizen moves the systems that we have put in governance to change the law and give reasons. The second bit is what ISLA is doing, is challenging the law through the courts. As you can see, that's not going very, very well so far because of what has happened in Kenya and in Uganda. But it should not feel like a daunting process. In the past 30 years, I myself, in terms of starting law reform of something which was not there. I've done it 5 times and I've succeeded 5 times. You know, where I've managed to change laws here in Malawi for the benefit of women. And it can happen, it should happen, but it all depends on the context of the country. You know, which country we're dealing with, which one works where. Here in Malawi, of late, of course, court-based law reform is happening, but for a long time, it was on its own motion, whereby the citizenry, the active citizenry, the ones who have taken the leadership mantle to reform laws, such as I was, would move systems of governance to change the law, and it worked. And, you know, I've just seen a comment there by Professor Faridabanda to say in England that changed in 2020. So there are 2 ways in which that can happen, but we should normalize change, particularly in matters where substantive equality is at stake. We need to normalize that, not just be satisfied that there's a law on paper. We need to fight to change the laws that are not working for women. So, yeah.
Thank you so much, Siori. That was very passionate. I'd like to pose my next question to Christine. Christine, what would a no-fault divorce law look like in practice?
Sena, thank you so much for that question. And I would like to say, I really liked the story that Justice Mwamba has given us, because that is exactly what happens in court. Yeah, whereby you file a petition and the other party does not contest the fact that they also want divorce, but they come and say the fault is not mine. They're just basically setting the record straight. And in the process of setting the record straight, there is a lot of acrimony, there's a lot of mess. It's a fight, basically. And so it doesn't serve any purpose, because at the end of the day, if both parties want the divorce, why do we need to focus on who did what and placing blame and, you know, finding fault and embarrassing each other and all that? So if we had a no-fault divorce system, it would look like this. The court would have an opportunity to focus on what really matters. So either one of the parties or even both could file for the divorce together, because you both agree that you want that marital obligation to be dissolved. And then once you file, the court will be looking at, do you have children between you two? Yes. So what happens to the children? Who has physical and actual custody? Who has access and visitation? How are the responsibilities divided between the two of you? Do you have properties between you? Who gets what, you know? So when you come out of court, you don't come out and then look at other lawsuits that you have to file, because as it is right now, you file for the divorce, and then you file again another case in the children's court. And then if you have property, you go to the high court, depending on the value. So you have 3 different cases. But if we could have no fault, there's a possibility we could just go and focus on what is important instead of investigating who did what and giving people, you know, pitting people against each other to drag each other through the mud. And then the tone would be less adversarial, which means that once you come out of there, it is just agreed we are no longer married, but we are not enemies. So we can still sit together and discuss about the PTA meeting. We can discuss about our children, you know, graduating and all that, because we didn't have all that trauma that was there in the fault-based system. Yeah. So because of the cordial nature of it and the diplomatic way in which we are communicating, then it sets a foundation for the future, because the divorce process is just a stage, and it's a very short stage. Within 6 months, maybe slightly longer or shorter, you already have your divorce decrees. But what happens within that period sets the tone for what is going to happen after that. So if this short period can be handled in a better way, then the family can still be maintained, because you're still a family. You're not husband and wife, but you're still a family, your father, mother, children, and there's a lot more involved, because according to culture, especially African culture, we brought 2 families together. You know, we have our in-laws who will always remain to be cousins and aunties and uncles of the children. They will still be in the lives of these children. And so they will still be in the life of the father and the mother. So I think that is what it would look like if the system was not fault-based.
Thank you, Christine. Carol, how do we respond to fears that a no-fault system would lead to a casualization of dissolution of marriages?
Thank you, Sena, for that question. And I would think that in my own reflection on this would be that a no-fault-based divorce law would not automatically lead to the fears that are coming out from the bench that this would be a disaster because it would lead to the casual dissolution of marriages. I would say that those countries that, number one, why I'm saying that is because in those countries that have a no-fault divorce law, there's no statistics, there's no evidence that demonstrates that there is a very high casual dissolution of marriages. And also, I know that nobody ever gets married with the view to get divorced. Everybody who gets married, there's a vow that they take that till death do us part. So nobody would wish that we're getting married and then tomorrow we're divorced because the law has made it easy. Marriages are about two lives coming together and people agreeing to be in a partnership for the betterment of the two people and perhaps the family that they will create and who they will become. So I would not think that anybody would be in that position to just approach the court casually for a divorce because the process makes it easier. And then also, I would think that even in those countries that have a no-fault divorce system, it's not an open check for divorce. The law still regulates how that dissolution of marriage would look like. When the law has used the irretrievable breakdown of marriage as the condition for dissolution of marriage, I said earlier that the law has also stipulated certain conditions that can speak to that irretrievable breakdown of marriage. We have seen, like in countries like the UK, Australia, South Africa, we have countries like Hong Kong, Germany, they have a separation period. And also following up from what Justice Mamba said, even in Zambia down here, we have that separation period that if couples have been separated for a certain duration of time, let's say for 2 years, for 5 years, like is in Zambia for, where you don't need to establish anything further, then the court grants you a divorce because it shows that the community of matrimony has already broken down. And then there is also that expectation that there cannot be reconciliation. So by the time the parties are coming to court to say that, or a one party or both are approaching the court to say they would like a divorce because that their marriage has broken down irretrievably, it means that they have gone through the emotions, they have processed it, and they have come to that decision that it is better we go our separate ways. And by that time, obviously, we have considered the possibility of reconciliation, and there is no chance that this marriage can be saved through reconciliation. So if those conditions are there in the law, then the law still regulates to a certain amount or to a certain degree the condition under which a marriage can be dissolved, therefore addressing the fears on casual dissolution of marriage. Thank you, Sena.
Thank you, Carol. Aria, this one is for you. I'd like to ask, how can feminists counter the use of family values to undermine gender equality in family law?
So I think with all these discussions, I think and this was really centering on narratives, we need to go back to the idea of what is family. I really liked what Christine said, that even after marriage ends, there is still family. I'm not married, but I do have my family. So, and then after defining what is family, then we have to decide what is the constitution and what is the law protecting. And again, we look at, like the constitution, the law, one protects the individual, not like if we have me practicing my Islam, and maybe some institution saying I'm not practicing it well enough, freedom of religious belief protects me, the individual, not the religion. In the same way, in marriage, it protects the participants. All the clauses I was reading about from Article 45 talks about consent, talks about equality, it talks about practice of recognition of culture. So I think these are the arguments we need to be making. First, dissent how family is being defined, because family is being redefined. We're having a narrative of what is family, and that's not the case. And then with that redefinition, then it follows all these kinds of ruling based on a wrong definition, based on the wrong things that are being protected. And so for feminists, we need the African Charter for the Feminist Charter, the African Charter, Feminism Charter says our ideological task is to recognize oppressive systems, and our political task is to destroy, dismantle these systems. And so we do have an ideological task to look at what the family is. We have an ideological task to look at what the law protects, and the law should protect the individual's ability to participate in family. It should protect consent. And every time these anti-rights people use family values, it's always a distortion of what the law wants. It's always a distortion of something, because family is not what they do define. And then if we also do not take this wider, the only way to argue these cases is to take a wider view of the things. If we narrow down to, I just want the divorce, then we will be caught in the ping pong of divorce instead of looking at what really the contestation is at. So it's part of our obligation, part of our ideological task as feminists to look at this contestation of what is this family values. And even when you look at the Constitution and when we argue about it, we should again have that ideological view. So like Section 2, which has been misused a lot, even with Parliament, the anti-rights groups argue that this section is talking about the sex of the couples. And so we might be caught, as a queer rights activist, I might be caught in fighting back. But if I look at it with this whole wider lens, I'm like, no, this thing is talking about my consent in marrying someone. It's consent that's the contestation. So anti-rights, all of these anti-groups have this way of just bringing us to argue about a smaller framework, and a smaller framework always based on a fallacy. So we need as feminists again to go back to this whole idea of like what's the thing we're fighting for, and then even when we make this appeals to the court, then we have like a big picture argument. Again, there's one. My last example is just last year, 2 Kamba women married under customary law went to court seeking a separation of their property. And the court ruled against them, said their marriage was unconstitutional. They just read out the Constitution. There's a clear clause in Kenya's Constitution that says it should provide for cultural marriages. So we should be able to argue holistically. So we should be able to say, oh, this part X does not cover cultural marriages at all. So it's unconstitutional in that way. The same part X violates consent. The same part X violates equality of the participants after marriage. So I think this is the lens should take, like, and we should, I think the burden again falls on us sometimes as petitioners to make the judges also see a blind side, like I said, because narratives are exactly that. They appear as common sense. And so unfortunately, we cannot just argue on what is presented. We have to also bring that other perspective that, like, let's take a pause. What are we protecting? Otherwise, we have rulings like this, which talk about, societal's control, societal stake, and all of these things. Yeah, I think I will stop there now.
Thank you, Arya. And lastly, Justice, you've already touched a bit on this, but I'd like to ask, how could a no-fault system simplify divorce proceedings?
Thank you very much. No-fault-based divorce system can simplify proceedings in several ways. And by way of just highlighting, one, there will be reduced litigation and disputes, in that the need to remove the fault shifts focus away from blame, decreasing the potential for prolonged disputes. Then secondly, no-fault divorce generally entails streamlined processes, which in other words are simpler procedures, often allowing couples to file petitions based on irreconcilable differences or an irretrievable breakdown of marriage, making the process more straightforward and faster, as you heard from the example that I shared with you. Then thirdly, there's lower legal costs with less contentious litigation and fewer evidentiary requirements. Couples may incur fewer legal fees, making the process more affordable. Then there's also focus on separation and custody issues. So without the need to address fault, courts can concentrate on fair division of property, child custody, and support, which are typically more straightforward and less emotionally charged. And then the last one, of course, will be encouragement of amicable settlement. No-fault systems often promote cooperative divorce negotiations, fostering agreements outside of court, which further expedites proceedings and reduce conflicts. And I would love to share with you that in Zambia, child custody, maintenance, and property settlement or sharing should, by way of mandatory procedures, be referred to mediation. So after the divorce process is done, we do not allow parties to file for custody and maintenance initially. We would want them to go and mediate the issues so that an amicable settlement is reached. So you find that if the fault-based system is removed, it will be very easy for the parties to go to mediation and reach amicable settlements. But where the divorce was so acrimonious, sending them to mediation to deal with custody maintenance will not work, because the environment will be very hostile and none of the parties will be willing to speak to each other. So I think in a nutshell, that is how I feel the no-fault-based divorce system can simplify proceedings in court. Thank you very much.
Thank you so much, Judge. Now I'd like to hand over the questions to the participants. I see Bobby from Burkina Faso. I apologize if I pronounced that incorrectly, has had their hand up. If you'd kindly unmute and please pose your question.
Ok, merci. Je suis Ido Bougué, je suis juriste au Burkina Faso. Alors, j'ai écouté avec attention donc l'exposé de Christine. Alors, quelque chose m'a marqué et que je voulais partager un peu l'expérience du Burkina Faso. Alors, Christine disait que dans les cas de divorce, 90% donc, des cas sont demandés par des femmes. C'est exactement en tout cas une réalité, même au niveau de Burkina Faso. Mais il y a un élément aussi qui m'a marqué, c'est les conséquences donc, sur la femme, surtout les conséquences émotionnelles lorsqu'il y a divorce. Alors, savez-vous que dans notre pays, ici au Burkina Faso, une femme ne peut pas se lever comme ça, aller chercher le divorce, parce que chez nous, pour divorcer, surtout le divorce contentieux, il faut que le motif que tu vas avancer pour le divorce soit déjà un motif légal. C'est-à-dire notre loi donne 5 motifs, en tout cas, de divorce. Donc, si la femme ne se reconnaît plus dans le mariage, n'est plus à l'aise dans le mariage, elle ne peut pas divorcer tant que le motif qu'elle va avancer est déjà légale. Et là, c'est un problème. Et aussi, un élément important, c'est qu'on dit que, voilà, une des causes de divorce, c'est l'adultère, c'est-à-dire le fait d'avoir des relations extra-conjugales. Mais notre loi, la même loi vient d'être révisée le 1er octobre 2025, qui dit que désormais, les mariages coutumiers et religieux qui sont transcrits, en tout cas, seront reconnus aussi comme étant des mariages légaux. Alors, vous imaginez un peu ce que ça va faire que lorsque on était avec son mari dans un couple, voilà, et après on apprend que ton mari a une autre femme et qu'il a des rapports avec celle dame, alors il est dans le cas d'adultère. Mais comment on fait les enfants qui sont innocents? C'est le plus important. Alors, autre élément d'émotion pour les femmes, c'est le partage des biens. Voilà. Et après le divorce, vous voyez, tantôt je disais tantôt qu'un mariage traditionnel ou religieux sera reconnu désormais si c'est le transcrit. Alors, comment protéger en tout cas ces différentes femmes qui ne sauront même plus à quel moment ou avec quelle femme ou quelle relation que son mari entretient. Voilà, puisque aussi la polygamie est aussi reconnue dans notre pays. Donc, c'est effectivement montrer en tout cas à quel point il y a vraiment des non-respects, en tout cas des engagements au niveau international pour le Burkina Faso, parce que notre loi qui vient d'être révisée a beaucoup d'éléments, effectivement, qui enfreignent donc aux questions d'égalité de genre et en tout cas et de sexe au niveau du Burkina Faso. Donc, je voulais effectivement partager l'expérience du pays pour effectivement, parce que j'ai beaucoup écouté en tout cas ce que les gens ont pu dire et ça m'a beaucoup marqué et c'est plus fort en tout cas au nom de notre pays et parce que notre pays dans un régime de transition militaire et il y a vraiment des restrictions de liberté individuelle et collective. Donc, effectivement, nous, à notre niveau, on cherche effectivement des partenariats effectivement pour, en termes de partage d'expérience, pour voir comment on peut faire le plaidoyer et en tout cas impacter sur les droits en tout cas de tous, mais surtout les femmes et les filles dans notre pays. Merci à vous.
Thank you, Bobby, for those reflections. Lucien, I see you have your hand up.
Bonsoir, bon après-midi. Je suis Lucien Yadunga, vient de Bukavu en RD. Je travaille pour Women's International Peace Center. Merci beaucoup pour l'occasion nous offerte. Merci pour le panéliste. Merci beaucoup. La thématique était très, très bonne. Je voudrais très sincèrement dire merci à Christine Moutoni. J'espère que j'ai bien prononcé ça. Par rapport aux conséquences liées au divorce. Dans le contexte qui est le nôtre, l'intervenant de tout à l'heure l'a dit, même chez nous en RDC, c'est le même cas. La plus grande partie, la majorité des cas de divorce sont introduits par les femmes pour des raisons diverses que nous connaissons tous. Je ne vais pas y rentrer. Mais ma question était plutôt de savoir, chère Christine, est-ce que quelle est votre appréciation ou appréhension par rapport aux gens qui soutiennent beaucoup plus le fait que euh, euh, mieux vaut un mauvais arrangement qu'un bon procès? Alors, tous nous œuvrons pour la paix, tous nous œuvrons pour le bien-être de la femme, de la jeune fille, et tout ça. Alors, on a tendance à croire que plus on va vers la loi, plus vers les structures qui, pour avoir un peu la raison, le divorce, plus ça fait mal parce que la loi du plus fort est toujours la meilleure. Et la plupart des gens préfèrent plutôt gérer leurs problèmes à l'amiable, à la coutume, hein, selon que nos ancêtres, nos coutumes, nos us et coutumes les disent. Christine ou quelqu'un d'autre parmi nos panélistes, est-ce que vous encouragez cela ou vous partagez cela? Ce n'est pas votre cas chez vous. Nous, à Bukavu, maintenant, à l'est de la RDC, comme vous le savez, nous sommes en guerre, il n'y a plus de cours et tribunaux, il n'y a rien. Alors, il y a vraiment beaucoup de cas de divorce qui, aujourd'hui, on ne sait pas quand est-ce qu'on le fera. Et il y a beaucoup, we are burning inside. On est en train de mourir entre nous-mêmes parce qu'on ne sait pas à qui adresser ça. Dès lors qu'il n'y a pas de cours et tribunaux, la loi, il n'y en a pas, donc c'est la jungle, quoi. Alors, quel est votre conseil, quelle est votre appréciation par rapport à ça? Sinon, j'en profite pour sincèrement dire merci à Isla de nous avoir associés à ce débat combien important. Merci beaucoup. Bonsoir à tous.
Thank you, Lucian. I will just pose a question that's in the chat and then I'll give the floor to the panelists to respond to the first set of questions we've received. So Yvonne stated that Namibia promulgated the Dissolution of Marriages 2024. There has been mixed reaction, particularly from churches. Men seem to be particularly happy. Does the no-fault system potentially affect women negatively? So I'd like the panelists to respond and give their reflections on the three statements given already.
I can just speak about the cultural thing. And again, I want to reemphasize on this whole idea of marriage and family as well. Yeah, one contributes to that, but actually they're two separate things. So in some cases, divorce helps a family continue. And I think this is something Christine said, and I don't want us to miss this. Divorce can allow two parents, two extended families that were brought together by a marriage to continue caregiving for the family. So I think, and also in cultural marriages, we've seen this happen a lot where there is a negotiation and there's communal care of children. So salvaging marriage does not necessarily equal promoting family or taking care of family. And I think this, like I said, narratives sometimes have the ability of conflating two things or putting things in a container. So we feel like we need to accept everything in order to make something work. I'd like to separate those two. So maybe divorce can help a family continue. Maybe divorce or the ability of a no-fault divorce can encourage younger people to get freely into marriage because they know, hey, I'm not being stuck here. I will not be subject to some law. I do not need to stay with my partner without making a legal commitment because I'm afraid of the consequences. So, and we need to have this lens on what it takes for families to function and what families really are in order to have, again, now the smaller discussion of divorce. Thank you.
Thank you, Arya. Christine, maybe you could pick up the question that was posed to you.
Yes. Unfortunately, I didn't understand the French, but I saw something in the chat by Lucien. So let me first pick up on what Arya has said. Yeah. What I got was, does no-fault divorce affect women negatively? And I want us to remember that the relationship that you have with your spouse is different from the relationship that you have with your children. So dissolving the marital status does not mean that automatically you have stopped being a parent to these children. It doesn't. The no-fault system will only make everything easier because now we are not fighting. Yeah, we are just agreeing that this marriage is not working, but everything else that we had built together still exists and we need to uphold it. So if it's about affecting women, women are already affected by divorce. And when it is fault-based, it is worse. And when it is all separated in different cases, like now you have to go to the family for divorce, then you go to the children's for upkeep, then you go to property, it's already lengthy and it's already expensive. And most women find it so difficult. It's emotionally draining and all that. So they give up. Somewhere along the line, they give up. And if we could now try to simplify this process, then it would be good for women, and not just the women, but everybody who is involved. Because by the time you're going to court, you've already gone, you've seen your family, you've tried to reconcile the differences, you've seen professionals, you've tried to reconcile, it's not working, you've seen your religious leaders, it's not working. So yes, divorce affects us, it affects everybody, but now when we say let's make it not fault-based, we are simplifying it for everyone. I really wish I understood what the other two people said, but I didn't get it. But we will address, for those who got it, we can address it together.
Thank you, Christine. Siodi, do you have any reflections on what Bobby said? Siodi? Oh, okay. Carol, perhaps you could pop in if you have any reflections.
Yeah, so I think it was important for the Francophone context that is very interesting to listen to and to see that the challenges are basically across the same across Africa. So I agree that obviously we have been here speaking about how divorce impacts on women, and it's interesting to see how that has come out in West Africa. And moving forward, I think it's important for us to pause back and ask, why are we seeking for a no-fault divorce system? It is simplified. It is for the simplification of the divorce proceedings with a need to continue preserving the relationships and the families that existed prior to the divorce without necessarily having to go through the convoluted, lengthy divorce processes and the trial process that it's very adversarial, very lengthy, very acrimonious, and just basically try to preserve the harmony that can exist between two people who had agreed to live their lives together till death do them part, but then life happened and they have to go their separate ways. So that's what I would say, that the conversation should continue happening within the continent so that we can see how this can be translated into the realities in Africa. Thank you.
Thank you so much, Carol. I see COD, I can see you now on my panel, but also just for your benefit, Christine. So the Bobby was sharing the Burkina Faso experience, and they were referring to how most women were asking for divorce in Burkina Faso, but they can't just file them for divorce, and that the grounds couldn't be frivolous. You needed a valid or justifiable reason to show why you don't want to be in the marriage. And when the woman is plaintiff, she must also satisfy the evidentiary burden. And marriages that are based on traditional values / religion are even more difficult to prove because with regards to the devolution of property, especially within polygamous marriages. So they were basically sharing how clearly it is not equal for men and women in divorce. So COD, do you have any reflections on the past few points?
I do. I did hear the gentleman from Burkina Faso's input. Basically, I think where the conversation is now going, it just goes to show that a simple change in the law, moving from fault-based to non-fault-based, will change the narrative around divorce. It's actually a good thing because right now the narrative around divorce is that it's a bad thing when it happens. That means we are all enemies. And, I'm sure some of you have gone to weddings where the former husband and the former wife are not talking to each other, but the child is standing, in between them. And they are presenting the son or the daughter, and they're not talking to each other, because of the acrimony that accompanied that. So, and on the happiest day of their child, the child will remember that my parents were not talking. and they're sitting, at the wedding reception, they're facing this way and they're facing, just because of the acrimony that accompanied the divorce. If the law changes, then it changes the narrative that it didn't work out, but it doesn't mean that the relationship stops. It's the marriage that ends. The relationship, as was highlighted earlier, continues. So it's just a matter of also, I think our courts need to revisit. Just as our state actors, I'm talking about the parliaments and the executive, it's just a matter of revisiting the thinking behind it. Divorce does not mean acrimony. Divorce does not mean bad people. Divorce just means it didn't work out. And, creating of a framework for existence after. Because, life goes on. So it's something that creates harmony in the society, rather than something that that causes, separation and, people behaving willy-nilly. It's actually to say it didn't work out because this is an institution. Marriage is an institution. It works out, it doesn't work out. Everybody knows. It's not a secret. Everybody, the whole world knows that it can work out or it doesn't work out. But let's say it doesn't work out. Can we make it a harmonious process, an ending, rather than an acrimonious thing? Basically, it's about building a stronger society, whereby when people go through a certain thing, they come out on the other side stronger, happier, more connected. Yeah.
Thank you so much, COD. Does anyone else have any questions? And for the panelists, it would be very helpful in case there are any more French speakers to just switch on the English channel on the interpretation in that event. Are there any questions? Let me check the chat quickly. Wow, I think our panelists answered everything. They're very preemptive, I guess. Yeah, so I would like to, wait, okay, so there are no more questions. Okay, perfect. Okay, firstly, I guess this is come to the point of closing the panel. Carol, are we happy with that? We're happy, okay.
Yeah, thank you.
Okay, thank you so much. Before we close, I'd like to take a moment to highlight two luckily there is a question that's just come up. Sorry, everyone. So in the chat, Ochiel Dudley asks, isn't Kenya's irretrievable technically no fault? And
I'll take that.
yes.
Yeah, so we spoke about this earlier to say that Kenya has both hybrid system. It has both fault and no fault. So that among the grounds for divorce is that the law sets out adultery, querity, desertion, and irretrievable breakdown of marriage. Then the law goes further to say, for you to demonstrate irretrievable breakdown of marriage, you must establish the grounds for divorce. That is, again, adultery, desertion, querity, and I remember the other one. So basically, what this means is that Kenya has a fault-based system because the irretrievable breakdown is established through the grounds of divorce. It is not a standalone ground that has all these other parameters that you have looked in that are existing in those countries that do not have a fault-based system. In those countries that do not have a fault-based system, irretrievable breakdown of marriage is not measured by grounds. It is measured by other conditions. For example, there's been separation for a certain period of time, that parties have approached the court, they have given a statement that the marriage has broken down irretrievably, and there is no possibility of reconciliation without the need to establish fault. So that's why we say Kenya is a fault-based system. I hope that answers Council Ochiel. Thank you.
Thank you so much, Caroline. I think that is a perfect place to end. Before we completely close and I get to thank this incredible panel, I would like to first take a moment to just highlight two very important upcoming events that ISLA is hoping that you'll join us for. The first one is the AU CVAG strategy consultation. So next week, ISLA, together with FOSFE Minister and Akina Mama wa Africa, will be hosting a public reading of the African Union Convention on Ending Violence Against Women and Girls, and they will be collectively analyzing the convention, reflect on its progress, identify gaps, and strategize on ways to engage more meaningfully with it. It will be live streamed on Zoom and YouTube and will be available in French, Arabic, Swahili, Spanish, and Portuguese. My colleagues will share the link to the website where you can access the full program and relevant resources. We encourage you to participate and help shape the future of the AU Convention. Secondly, we will be having another ISLA conversation on the 3rd of October, which is titled Sexual Harassment and the Law, Race and Gender in the Mbenenge Tribunal. This two-part conversation will explore the intersection of race and gender in the Judicial Conduct Tribunal's investigation into Selby Mbenenge, a South African judge accused of sexually harassing a judge's clerk. We will reflect on how sexual harassment affects women's rights to exist and work safely within legal institutes, and how specifically Black women are portrayed and perceived in courts, in legal proceedings, and in the law itself. Again, my colleagues will be sharing the event link in the chat, so please keep an eye out as well on our socials and register. It will be, we promise, a very interesting conversation. And as we close today's webinar, it is clear that how we structure divorce law is not just a technical legal issue. It's a reflection of whose dignity we value, whose pain we acknowledge, and whose rights we choose to uphold. We've heard today from all of our panelists how fault-based divorce systems are still common across many African countries and often deeply harmful to women by forcing individuals to publicly prove wrongdoing. So let's not let this conversation end here. And here's to let it be the start of deeper advocacy, cross-border learning, and legal transformation. Thank you for joining us. Thank you, CEOD, Christine, Carol, Justice Mwamba, and Aria for being our panelists, for providing your insights, courage, and commitment to justice. Thank you, everyone.
Thank you. Bye-bye.
Thank you. Bye.
Thank you. Thank you, everyone.
Thank you.
Thank you.
Thank you.